Hello, my name is Dave, and I am here to discuss the protection of plant varieties and the controversy surrounding UPOV. Firstly, before ascertaining the nature of the controversy, a fair understanding of UPOV itself must be ascertained. The Union for the Protection of New Varieties of Plants, UPOV, is an international system established in the 1960s for recognizing and protecting the rights of plant breeders. As of the 15th of April 2016, there are 74 members, the majority of which are signatories to the 1991 Convention, hereafter UPOV 91. Plant breeders' rights, enabled by UPOV, are a form of sui generis intellectual property protection. The phrase plant variety protection is somewhat of a misnomer. UPOV does not actually protect plant varieties. Instead, it grants a number of rights to breeders akin to those of a patent holder. Furthermore, UPOV convention is not self-executing. To gain effect, each member state must enact legislation consistent with its requirements. To gain a proper understanding of the type of rights granted unto breeders, a basic determination of the relevant terms is necessary. The term breeder is broad and encompasses an actual breeder, an employee of one, or the successor of either. Furthermore, it may be a plantsman, a farmer, a company, or a scientist. The exclusive rights granted unto a breeder are comprehensive and extend to almost any use of the protected variety unless authorization is given. Typically, license fees are paid to access the use of the variety, as most commonly done in farming. In order to qualify for such rights, a plant variety must be new, otherwise called novelty, distinct, uniform, and stable. As with every form of IP protection, there exists the necessary exceptions. These include the use of the variety privately and for non-commercial purposes, for experimental purposes, and for breeding other plant varieties. In addition to these, there is an exception known as the farmer's privilege. It is predominantly from the concept of this provision, amongst other things, that much of the controversy surrounding UPOV emanates. The provision, simply put, allows an exception for farmers to withhold seed of a protected variety, so that they may be re-sown on the same farm and not for the purposes of selling. The automatic exception of the farmer's privilege existent in UPOV 78 was removed in UPOV 91, and in its stead, it is left open to the decision of each member state whether or not to enable such an exception. The live issue surrounding UPOV is quintessential to that of all IP law. That is, the balancing act. In this case, like many, it is the struggle to create an IP regime that simultaneously promotes innovation whilst protecting public interest, most notably economic development and poverty alleviation. UPOV, most particularly UPOV 91, has polarized opinions as to whether or not the regime strikes an appropriate balance. Critics of the regime compellingly argue that the regime favors large corporations and their monopoly over the field, in turn favoring developed nations, whilst developing nations struggle to survive and evolve in its wake. Such arguments emphasize the effect that certain aforementioned restrictions have on small farmers. In other words, UPOV 91 has attracted critique that it is biased towards profit feeders at the expense of farmers, as compared to its predecessor. Proponents of UPOV would point out that both UPOV 78 and 91 require novelty, despite the fact that 78 implicitly does so. Thereby, their position would be to reaffirm that the purpose of the system is to reward innovation, not to monopolize product, nor to exploit developing nations or age-old farming practice. Simply put, neither regime grants protection to a variety already in existence and thereby widely used in farming. Despite this, it has been argued that the balance would be better achieved if UPOV worked together with other international treaty frameworks, most notably the Convention for Biological Diversity. Furthermore, the aforementioned requirement of novelty still coincides with the strengthening of breeders' rights, which affects small farmers in particular, and their dependency on the seed market. It has been proposed that the mandatory exemption, as exists in UPOV 78, should be reinstated for smallhold farmers, leaving it to the discretion of member states regarding other categories of farmers. Another issue surrounding the controversy concerns the World Trade Organization Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS, which required developing nations to provide either patent or sui generis unique plant protection by at least 2005. Despite the fact that there is no mention of UPOV in TRIPS, criticism has been levelled at certain developed nations that they have used this requirement to pressure developing nations into joining UPOV by accusing them of impeding the evolution of global trade. It is also noteworthy that UPOV 91 no longer prohibits dual protection, that is, protection by both UPOV and patent protection. The rights and exemptions of the two regimes do not line up, thereby creating ambiguity and increasing litigation. Whilst UPOV has proved that it certainly promotes innovation, it is certainly viable to see the position critics have put forth, particularly in respect of UPOV 91, that it has tipped the scales too far to the detriment of farmers and developing nations. Only time will truly tell how these developments come to fruition, but at the present it would appear that a comprehensive review of UPOV 91 is indeed necessary.